Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here with a quick video. As expected, Jennifer Bonjean has requested a delay in the sentencing for Mr. Kelly as all of these motions play out, and she also stated on Twitter that her response to that 150-page response to her motion from the government, she will be filing a response on Monday, I believe. Let's see, second, third. Yeah, I believe Monday she's going to file her response. But in any event, here is a letter that she wrote to Judge Donnelly. It says, "Dear Judge Donnelly, undersigned counsel respectfully moves this court for an order adjourning Mr. Kelly's May 4, 2022 sentencing hearing until a date after his trial in the United States District Court for the Northern District of Illinois, which is scheduled to commence on August 1st, 2022. Undersigned counsel represents Mr. Kelly in the Northern District of Illinois case because one of the co-defendants in the Northern District of Illinois case has demanded trial. District Court Judge Lennon Weber has emphasized that the August 1st trial date is firm. Critically, undersigned counsel seeks an adjournment of the sentencing hearing in the case because she cannot adequately protect Mr. Kelly's constitutional rights at sentencing in this case without compromising his Fifth Amendment rights in the Northern District of Illinois. The government objects. Of course they do. Undersigned counsel has an ethical and constitutional obligation to investigate and develop mitigation evidence for use at sentencing, and then she cites the case Wiggins versus Smith, and which was heard in 2003, and then Strickland versus Washington, which was heard in 1984, and then ABA Standards for Criminal Justice Standard 4-4 1C and D, stating that defense counsel's investigative efforts should commence promptly and should explore appropriate avenues that reasonably might lead to information relevant to the merits of the matter, consequences of the criminal proceedings, and potential dispositions and penalties, and defense counsel should determine whether the client's interests would be served by engaging fact investigators, forensics, accounting, or other experts or other professional witnesses such as sentencing specialists. Emphasis added. The development and presentation of mitigation is a critically important part of sentencing, particularly after United States versus Booker, which was heard in 2005, rendered the federal sentencing guidelines advisory. Booker placed a renewed emphasis on the all-encompassing facts set forth at 18 U.S.C. section 3553A that a sentencing court may consider in fashioning an appropriate sentence for a defendant. And then it goes, of course, my page is stuck, as always. Okay, a preliminary sentencing investigation has revealed that Mr. Kelly himself is a rich source of mitigation that should be further developed, potentially with the aid of a mitigation expert. However, undersigned counsel has gave concerns that a comprehensive examination by a mitigation expert could interfere with Mr. Kelly's Fifth Amendment guarantees in his Northern District of Illinois case. To put a final point on it, undersigned counsel cannot advise Mr. Kelly to be examined or interviewed by a mitigation expert for sentencing in this case, if his words might be used against him in some manner at his pending Northern District of Illinois trial. Mr. Kelly should not have to compromise his Fifth Amendment rights in his pending criminal case in the Northern District of Illinois to develop and present comprehensive mitigation evidence in the instant case. Accordingly, Mr. Kelly respectfully requests that this court adjourn his sentencing hearing until after his Northern District of Illinois trial. The government is not prejudiced by adjourning Mr. Kelly's sentencing hearing 3 months. The request is reasonable given the constitutional issues at stake. Mr. Kelly is facing a serious and lengthy sentence of imprisonment. He should not have to forego presenting mitigation evidence at his sentencing hearing out of fear that his words could be used against him at his upcoming trial. The foregoing concerns aside, undersigned counsel seeks to adjourn the sentencing hearing for 60 days on account of competing professional obligations and because she has not had an adequate opportunity to develop mitigation in this case. Undersigned counsel is working diligently to prepare for Mr. Kelly's sentencing hearing, but is still focused on post-trial motions, which will not be fully briefed until April 4th, 2022. Undersigned counsel has significant litigation scheduled over the next 2 months, including 3 post-conviction evidentiary hearings in the Circuit Court of Cook County, Illinois, People v. Nelson Gonzalez, People v. Abrigo and Kane, and People v. Masonet. Furthermore, undersigned counsel is commencing a 2-week jury trial in Los Angeles County on May 23, 2022 in the matter of Huth versus Cosby. Even if this court refuses to adjourn sentencing until after Mr. Kelly's Northern District of Illinois trial, undersigned counsel respectfully requests an adjournment of 60 days so that she can satisfy her existing professional obligations while affording Mr. Kelly the effective assistance of counsel to which he is entitled. Respectfully submitted, Jennifer Bonjean. So Miss Bonjean is a very, very, very busy woman, and she's basically trying to protect his constitutional rights because part of the sentencing is that the person who has been found guilty of a trial, they have to talk to counselors, they have to talk to the probation office, and they go through all these series of interviews and counseling and that type of thing to get an understanding of their mind frame and how they grew up, anything, that they have experienced in their lives. And we know that as a child growing up, he was molested by several people in his family, and so they'll take all of that into consideration when they're determining their recommendations for his sentencing. And so what she's saying is she doesn't want anything that he talks about to these specialists, to try and help him get a reduced sentence, not get life in prison. Like, he wants them to have sympathy for him, things that he's experienced and gone through in his life that could have screwed his way of thinking when he was, dealing with these different women in his life. And so she wants all of that put on hold until after the Northern District of Illinois case, because anything that he says, all of this is documented, is recorded via video, then the government could turn around and take that information and use it against him. And I find it also interesting because what's her name? The federal attorney from Houston, Texas, that was coming down to sit in on the cases, she actually did a Q&A on her Instagram channel, and I meant to reach out to her and ask her if I could share that on my channel so you guys could see it, and I'm going to do that after I do this video. But basically, that probation services procedure, where they go in and talk to the people, they review your past history and that type of thing, that's usually a confidential record, because I know, in a case with somebody I know that's going on now, we were unable to see what they came up with when they were considering the resentencing guidelines. And so I guess the government has access to it and they could use it against him, whereas other people, the public, can't see it. But anyway, Jennifer Bonjean is requesting at a minimum a 60-day delay in sentencing in the Eastern District of New York case, and in addition to the 60-day delay, which would be a minimum, she is asking that his sentencing in the Eastern District of New York be delayed until after the Northern District of Illinois case is resolved. So that's it for me. Just wanted to bring you guys this update. Go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.